Thank you for joining the California Gambling Control Commission's presentation on understanding the application and background process. The Commission is the licensing and regulatory body in the controlled gambling industry. The Commission holds meetings typically twice a month for the consideration of initial and renewal applications, transactions, evidentiary hearing referrals, default decisions, and other matters. The Commission also sets policy and establishes regulations. The Commission is the administrator for the Indian Gaming Special Distribution Fund and trustee over the Indian Gaming Revenue Sharing Trust Fund and Tribal Nation Grant Fund. The Bureau of Gambling Control is the investigatory and enforcement arm under the Gambling Control Act. They receive the application and perform the investigations, provide a copy of the investigation to the Commission and applicant with their recommendation. They investigate complaints or concerns that are brought forth from the public and will issue accusations and enact emergency orders on cardrooms if warranted. Time for a fact checkpoint. Is it the Commission or the Bureau? We understand there may be some confusion regarding what each agency's function include. We've included some clarifying questions and answers. Who accepts the application? The Bureau of Gambling Control is the only entity that accepts the applications. Who conducts background investigations? The Bureau of Gambling Control is the enforcement and investigatory body. Therefore, the Bureau of Gambling Control is the only entity that conducts the background investigations. Who contacts the designated agent or applicant to provide notification that the applicant is on calendar for a meeting? The California Gambling Control Commission is the entity that will reach out to the designated agent or applicant to provide them notification that they are on calendar for an upcoming meeting. Who makes recommendations for approval or denial to the commissioners? Both the Bureau of Gambling Control and the California Gambling Control Commission will make recommendations for approval or denial to the commissioners. Recently, the Commission made significant changes to the California and third-party providers of proposition player services licensing structure under the California Code Regulations, Title IV, Division 18. These changes are effective as of January 1, 2021. Some changes include the creation of requirements and standards of representation for designated agents, the elimination of the gambling business program, the discontinuation of third-party registration program, which is replaced by the issuance of temporary licenses instead, new worker classification, new applications and supplemental information forms, and the requirement to submit fingerprints with each application, initials, and renewals. A part of the regulatory changes effective on January 1, 2021, is the terminology used when describing the various license types within the California cardroom industry. An owner category license means a cardroom owner type license or a third-party provider of proposition player services owner type license, whether the license is an initial, renewal, interim, or temporary. An owner category license includes any cardroom or third-party provider of proposition player services, owner or endorsee. An employee category license means a cardroom employee type license or a third-party provider of proposition player services, employee type license, whether the license is an initial, renewal, interim, or temporary. An employee category license includes any cardroom key employee or work permittee, and any third-party provider of proposition player services, supervisor, or worker, including subcontractors or independent contractors. Third-party providers of proposition player services workers include what we previously defined as players and other employees. This chart displays the number of active and pending licenses, registrations, work permits, and findings of suitability applications as of November 10, 2020. As you can see, we currently have over 12,000 active licenses issued to the industry and 2,500 applications pending. It is worth noting 86 state gambling licenses have been issued to gambling establishments. 23 of those are not currently operating. All applicants are required to submit applications and supplemental information forms specific to their license type. The current application and supplemental forms can be found on both the Bureau and Commission websites. Applicants need to read each question thoroughly and confirm their understanding of what the question asks before answering. The Commission has created a must-dos brochure that can be found on the Commission's website under Helpful Resources within the Education menu. This brochure can assist applicants while filling out their application and supplemental forms. If in doubt on whether an applicant should disclose a matter, it is highly recommended the applicant disclose the information or contact the Bureau of Gambling Control for clarification prior to submitting their forms. When do you need to submit your application for the third-party providers of Proposition Player Services category? Upon the effective date of the new licensing regulations, third-party providers of Proposition Player Services registrants that have been summoned for licensure by the Bureau will be automatically converted to temporary licenses at the expiration of the current third-party provider of Proposition Player Services registration. Renewals for registrations will only be issued within the first 6 months after the effective date of the new regulations and will only be valid for 1 year. For endorsed licensees, applications must be submitted within 10 days of appointment to an officer position. Ownerships must receive transaction approval and be issued a license prior to receiving distributions. For employees, applications are required to be submitted to the Bureau prior to working. The Bureau will provide a recommendation for the temporary license within 15 business days of receipt of results of the live scan. The temporary license will be valid for a period of up to 2 years. All renewal applications are due 120 days prior to the expiration and upon approval will be valid for 2 years. When do you need to submit your applications for Cardroom category? For endorsed licensees, applications must be submitted within 10 days of appointment to officer positions. Ownerships must receive transaction approval and be issued a license prior to receiving distributions. For Cardroom employees, applications are required to be submitted to the Bureau prior to working. The Bureau will provide a recommendation for the temporary license within 15 business days of receipt of the results for the live scan. For key employees, the temporary license will be valid for a period of up to 2 years. For work permittees, the temporary license will be valid for up to 120 days. For all, renewal applications are due 120 days prior to the expiration and upon approval will be valid for up to 2 years. Please note, this is a change for work permits, in which renewal applications used to be due 90 days prior to expiration. Now they are due 120 days prior to their expiration dates. When do you need to submit your applications for tribal? Tribal key employees who are licensed by their respective tribal gaming agency or TGA will be notified by the TGA directly to fill out an application for finding of suitability tribal key employee and will submit the application to the Bureau of Gambling Control. State-issued findings of suitability are valid for up to 2 years to align with the TGA expiration. For gaming resource suppliers, they are to submit an application for finding of suitability gaming resource supplier or financial sources provider upon meeting the following 3 criteria. 1. Provide gaming resources as defined in the California Tribal State Compact. 2. Are licensed with at least 1 California Tribal Gaming Agency. And 3. Conduct at least $25,000 within a 12-month period with the California Tribal Casino. Gaming resource suppliers who are issued a state finding of suitability, those are valid for up to 2 years. Renewal applications for gaming resource suppliers are due 120 days prior to expiration and upon approval will be valid for another 2 years. M&Ds are applications that must be submitted and approved prior to operating in California. Registrations are valid for 1 year. M&Ds are gaming equipment manufacturers or distributors. Renewal applications for M&Ds are due 30 days prior to expiration. Having a conviction on your record is not always an automatic denial or an automatic strike against you. The Commission will look at an applicant's background as a whole. With that said, please ensure applicants disclose all convictions, even those that have been expunged. Please ensure that any traffic violation received was in fact a misdemeanor and not an infraction, and disclose the violation on the supplemental form. Provide in your statement to the Bureau as much detail as you can recall. Failing to provide information may lead the Bureau to recommend denial of your application. Above all, be honest with what occurred, as the Bureau will be verifying any statements provided. If you have questions or doubts, you can check your sentencing paperwork for probation information. Don't leave out facts in the statement. It is important the applicant prove that they are honest and not hiding anything. Applicants can receive a copy of their driving record from the local Department of Motor Vehicles for California, and copies of their criminal conviction history may be requested from the Department of Justice's Criminal Records Unit. Remember, honesty is the best policy. There are 3 levels of charges: infractions, misdemeanors, and felonies. Infractions are not required to be disclosed and are minor in nature, such as parking tickets or seatbelt violations. Misdemeanors are required to be disclosed and are more serious in nature. These include such convictions such as driving on a suspended license, driving under the influence, and some theft. Felony convictions are the most serious in nature, which include crimes such as murder, battery, manufacturing, and the sale of drugs. Felonies are a mandatory denial unless the conviction has been reduced to a misdemeanor and further expunged in some cases. A wobbler is a penal code violation that may be charged as more than one level of criminal conviction. For example, theft can be charged as an infraction up to a felony, depending on the value of what was stolen and prior conviction history of the accused, which is why it is very important for the applicant to verify their conviction history if they are in doubt. The Commission modified its regulations and made several changes to the application and supplemental information forms. This was to help reduce confusion and to ensure consistency throughout applicant types. One of the major changes is the requirement of all criminal history, misdemeanors and above, to be disclosed, not just the previous 10 years, as some supplemental information forms previously required. Another change is the disclosure of 10 years of financial history when requested. However, work permittees and third-party providers of Proposition Player Services workers are not required to disclose financial history. Here you see an excerpt of the criminal history section on the supplemental forms. This slide provides you with website addresses for additional information from the Department of Motor Vehicles for driver history records and the Department of Justice for fingerprint records. It's time for a fact checkpoint regarding criminal convictions. Should a DUI be disclosed? Yes. What can happen if the applicant does not disclose? It can lead up to and including denial of the permit or licensure. What type of level of conviction is a theft? A theft can be an infraction, misdemeanor, or felony. Is it easier to just say nothing and just let the Bureau find out? No, absolutely not. In fact, it will almost certainly complicate matters and subject the applicant to an evidentiary hearing, which may result in a denial. When disclosing an applicant's employment history, please be as accurate as possible. If there is concern regarding dates of employment, provide an attachment with an explanation. Remember, if in the past the applicant has worked for a tribal casino, gambling establishment, or third-party company, the Commission and Bureau has record of this information if the applicant has previously applied. Even if you disclose information on a previous application, please disclose on the current application. Please disclose the reason for separation as employment is verified. There are differences in causes for separation. The terms laid off and terminated both have very different meanings. Laid off means to be released from employment for reasons not related to you. It is not performance related. Being terminated means that they are released from employment due to reasons specific to them, typically due to performance or lack thereof. Resignation means that the applicant left the job voluntarily. The term let go is too vague. It is unclear if the employment ended because of the applicant's actions or not. If you are asked for further information regarding the circumstances of ending employment, please be as accurate as possible, even if you don't remember the circumstances. It is important to provide as much information as the applicant can recall. Disclose all gaps in employment and how the applicant supported themselves during those gaps. Again, honesty is the best policy. It is recommended that the applicant reviews a past resume to refresh their memory regarding past employers. Non- or inaccurate disclosure of a past employment history record can be a factor when determining the applicant's suitability. Here are two examples of filling out the employment section. The example provided on the top provides an adequate reason for why they are no longer employed. However, the example on the bottom provides too vague of a reason. When stating accumulated too many points, it leaves a lot of unanswered questions, such as how did they get too many points? What exactly does that mean? What did they do to get too many points? The applicant will be asked to provide additional information answering these types of questions. A separate sheet of paper can always be used if necessary to provide a more detailed response. Time for a fact checkpoint regarding employment history. With the following scenarios, what type of employment separation would you consider this to be? The employee needed to cut costs and ended the employment relationship for non-work performance related reasons. What type of situation would you consider this separation to be? The correct response is a layoff. The employer ended the relationship because the employee didn't show up to work. What type of situation would this separation be? Employees sometimes see this as they quit. However, unless they actually resigned before they were fired, this is traditionally viewed as a termination regarding the attendance. The employee said, "Forget this, I'm out of here." What type of separation would this be? The correct answer is resignation. The employee said, "Forget this, I'm out of here," but right before they were about to be terminated for insubordination. What is your response now? The correct response would be a resignation in lieu of termination. For our last example, the employee said, "You take this bleep pizza," and was let go on the spot. What type of separation would this be? This is a termination. The next part in the process is the financial aspect of the background investigation. Understanding key terms and their meaning is vital to ensure the applicant can complete the supplemental package in a satisfactory way. There are several types of financial terms that are considered derogatory. However, they will not preclude the applicant from being licensed or found suitable as long as they are disclosed. These include bankruptcies, collection accounts, charge-off accounts, foreclosures, and judgments and liens. It should be noted that if an applicant still has an outstanding financial account at the time their background investigation is provided to the Commission, a condition may be recommended to the Commissioners for placement. The condition in most cases requests status updates be provided until the account is resolved. At the Commission meetings, the applicant will be asked to confirm their understanding and acceptance of the condition. With that said, here are some tips to ensure the applicant know what to disclose regarding the financial portion of their application. Read the question in full and ensure if they are required to disclose the information from the past 10 years or within their lifetime. Ensure the applicant discloses all bankruptcies, including dismissed, discharged, or open and ongoing cases. They should also disclose any foreclosures, even if they were included in a bankruptcy. All debt collections, including charge-off accounts, should be disclosed. Business investments and its associated licenses, even if it was not profitable. Any judgments or liens, Please note that even if the applicants were not aware of the judgment or liens, they are still responsible to ensure they are resolved. They are also required to disclose any litigation, whether they are the plaintiff or the defendant. As the application can be quite intensive, and we understand that applicants forget accounts, especially when they happened years ago, we highly recommend the applicant pull a credit report to reference when completing the supplemental application. When in doubt, if the applicant should disclose an account, the best practice is to disclose the account and/or reach out to the Bureau for clarification. Here, you can see that both questions are looking for information that occurred within the last 10 years. It is important that the applicant check the correct box and provide any explanation necessary. In some cases, the applicant will be required to provide written documentation that substantiates their answers. Also, when reviewing the forms, ensure all questions are answered, as non-answered questions may be considered non-disclosures. In some cases, applicants may hold power of attorney over someone. Be sure to disclose that information as well. It's time for a fact checkpoint regarding how far back do the questions ask. As you can see, there is a variation on who is required to disclose what information and how far back, ranging from not being required to disclose if it occurred within the last 10 years, to disclose if it occurred within the applicant's lifetime. The main factor on determining who is required to disclose what depends on the applicant's responsibility. For example, a key employee's responsibility includes making gaming floor decisions, while a work permittee may be responsible for food and drink disbursement or janitorial functions on the gaming floor. As such, the key employee will have to undergo a more thorough background investigation. This brings us to applicants responding to Bureau inquiries in a timely manner. When an application is submitted to the Bureau, all applicants are expected to participate in proving their suitability to hold a license or finding of suitability. As such, during the course of the Bureau's background investigation, the Bureau may reach out to the applicant for additional information or an explanation to clarify information found during the course of their investigation. The Bureau will provide a written request to the applicant and/or designated agent with a due date. The due date ensures the background proceeds in a timely manner, as the goal is to get the background investigation to the commissioners for consideration as soon as possible. A reminder that it is important to read in full what is being asked of the applicant to provide and to respond accordingly. If the applicant does not respond to the question in full, the Bureau may have to reach out again and obtain another response, which will delay the completion of the investigation. Please note, failure to respond or failure to respond in a timely manner to the Bureau may result in a denial recommendation and/or denial. It is important to understand the process that occurs once an application is submitted to the Bureau. Upon receipt of the application, applications are assigned to a Bureau analyst based on the date it is received. The Bureau analyst will review and verify the application package, which includes the initial application, the supplemental form, and the supporting documentation for completeness and accuracy, and they will determine if there is any derogatory information. The Bureau analyst will contact the applicant to answer any questions, clarify any discrepancies, or request additional documentation be submitted. Contact will be mostly through written correspondence via email and/or U.S. mail. Based on the information provided, the Bureau analyst may contact the applicant multiple times. During the background process, the Bureau may request an additional deposit to complete the investigation. The deposit must be received by the Bureau before it can make a recommendation to the Commission. Once the Bureau analyst has all the information needed to make a recommendation, they will write the background investigation report and submit to management for review. Once the report is approved by management, the Bureau analyst will submit the report along with the recommendation of approval or denial to the Commission. If the Bureau intends to recommend denial or conditional approval, it will notify the applicant and allow the applicant the opportunity to meet with Bureau representatives to discuss the general reasons for denial or conditional approval prior to submitting the report to the Commission. Keep in mind, as previously noted, it is the applicant's burden to prove his or her qualifications to receive a license or finding a suitability. The Commission may deny a license to an applicant that fails to provide information, documentation, and assurances requested by the Bureau. The Commission typically has public meetings twice a month in order to consider the applications and either approve the application, refer the application to an evidentiary hearing, withdraw the application, or table the application. Therefore, once an application has been placed on an agenda for consideration, the applicant will be sent a notification via U.S. mail or email. The notification letter will be sent 10 calendar days prior to the meeting and will include a copy of the Commission meeting's agenda and a Commission staff memorandum, if applicable. The notification letter provides the date and time of the meeting and will advise if attendance is requested. Please note, if the application is placed on open session, it is best practice to participate in the meeting. It should also be noted that even if attendance is not confirmed, the Commission still has the authority to act on the application. However, if the Commission has questions for the applicant and they are not in attendance, the Commission may table the matter until the next available Commission meeting. Typical items found on the Commission's open session for consideration are cardrooms, including owners and financial interest holders. This includes their initial and renewal applications, cardroom purchase agreements, key employee initial applications and renewal applications, if there is any derogatory information, if a condition is being recommended, or if a condition is being removed. Work permits issued by the Commission. Initial and renewal applications may be heard on open session if derogatory information is found or if a condition is being recommended. Initial and renewal applications for third-party businesses, including their owners, will be heard on open session. Initial applications for third-party supervisors will be heard on open session as well. Renewal applications for third-party supervisors will be placed on open session if derogatory information is found, a condition is being recommended, or a condition is being removed. All other third-party licensing type initial and renewal applications may be heard in open session if derogatory information is found. Initial and renewal tribal key employees will be heard if derogatory information is found, a condition is being recommended, or a condition is being removed. All gaming resource suppliers, initial and renewal applications will be heard on open session. Manufacturer or distributor, initial and renewal applications may be heard in open session if derogatory information is found. With regard to the totality of the licensing process, here are some key factors to remember. Once an applicant has applied for a position in the gaming industry, the employer should conduct their own due diligence hiring background. Please note that if the employer determines that an applicant was previously denied a state gaming license or their application was withdrawn with prejudice, which bars an applicant from reapplying for 1 year, the applicant is precluded from employment. Once the applicant is hired and meets the criteria to obtain a state gaming license or finding of suitability, the applicant should submit their application to the Bureau. Some notes about the application include: it is the applicant's responsibility to provide their suitability. Therefore, review all of the questions very carefully and ensure all the questions are answered completely and provide any additional information that substantiates an answer or statement. When the applicants sign the application, it is under penalty of perjury. Also, when completing an application, the applicant can elect to have a designated agent, also known as a DA, that can be their representative and/or speak on their behalf. Once the application has been submitted, the Bureau will begin their background investigation. As noted before, they will ensure the application is complete and verify all information is submitted. After the Bureau has completed their background investigation report, they will submit to the Commission for placement on the Commission meeting agenda. Once Commission staff receives the Bureau's background investigation report, the Commission has 120 days to take action on the report. As such, Commission staff reviews the reports for completeness and provides clarification where needed, and schedules the application for Commission consideration. Once a Commission meeting agenda has been finalized, Commission staff will send a hearing notice to the applicant 10 calendar days before the meeting. The notice will include a copy of the agenda and a Commission staff memorandum if one was prepared. Please note the memorandums are distributed to both the Commissioners and the Bureau as well. A couple days before the meeting, Commission staff will reach out to the applicants on open session and confirm participation in the Commission meeting. If the applicant is unable to participate, please indicate so and provide a reason. If the applicant wishes to have the item moved to a different meeting so they can participate, please let the Commission staff know immediately. Please note, even if the applicant is unable to participate, it does not preclude the Commission from taking action. At the Commission meeting, the Commissioners consider all applications agendized. The Commission may approve, withdraw, refer to an evidentiary hearing, or table an application. Commission staff will send final action letters to the applicant summarizing what occurred at the meeting. If approved, no further action will be required until the applicant's renewal period. If approved with a condition, the applicant will be responsible for complying with the imposed condition. No reminders will be sent. Please note that non-compliance of the condition may result in a referral to an evidentiary hearing upon the applicant's renewal. Here is a flowchart that breaks down what occurs once an initial application is submitted. Here is a flowchart that breaks down what occurs once a renewal application is submitted. It should be noted that in some cases, renewal background reports consist of a simple checklist. This means there has been no significant changes and no derogatory information has been found. As such, a Commission staff memorandum may not be prepared. In those cases, they will most likely be placed on the consent calendar for consideration. This flowchart shows the process when an application is referred to an evidentiary hearing. Once the application is referred to an evidentiary hearing, the next step is determining if the application will be referred to 1. A Gambling Control Act or GCA hearing. This means the case will be heard in front of the Commissioners. Or 2. An Administrative Procedures Act or an APA hearing. This means the case will be heard in front of an administrative law judge. A referral to an evidentiary hearing can go two ways: a Gambling Control Act or Administrative Procedures Act hearing. A notice of defense is required, and if not received, the matter is defaulted, which is generally a denial. The Commission's website has some helpful tips and information for the GCA evidentiary hearing process. A pre-hearing conference will be scheduled and are to assist in the preparation of the hearing. The Commission has the audio of past hearings on its website, which can assist when preparing for an upcoming hearing. When an application is referred to a GCA evidentiary hearing, this will be the applicant's time to provide letters of recommendation and bring witness testimony. Applicants can have a layperson or an attorney represent them. This is a hearing that is before the Commissioners. A Deputy Attorney General with the Attorney General's Office will be representing the Bureau with a statement of issues or statement of particulars. Regulations do not allow for the scheduling of a hearing any sooner than 60 to 90 days. When an application is referred to an APA evidentiary hearing, it is presented before an administrative law judge at the Office of Administrative Hearings. The ALJ hears the testimony and evidence and prepares their proposed order, which is then sent to the Commission. The Commission can either accept, modify, or reject the proposed order. Following the Commission's determination, there are additional remedies such as a request for reconsideration or a writ of mandate. If you have questions regarding the information provided, you can contact the Bureau or Commission via the numbers listed, or visit our websites for more information. We hope this information has been helpful. Thank you for joining us.